Now, certain special reporting procedures were added in the year 2013 pertaining to sexual offences in section 154 of the code, which provides that where information is given by a woman victim of an offence of acid attack or sexual harassment or rape, then such information shall be recorded by a woman police officer or any woman officer, and where such woman is temporarily or permanently mentally or physically disabled, then such information shall be recorded at her residence or at a convenient place of her choice in the presence of an interpreter, and at the same time the same recording of statement must be videographed as well. Now, a welcome provision is added in the Indian Penal Code by the same Amendment Act of 2013, which prescribed for punishment for those officers who refuse to register FIR in these cases. Such a provision can be found in section 166 capital A subclause C of the Indian Penal Code, which prescribes punishment for minimum 6 months and up to 2 years rigorous imprisonment. Now, other than these statutory provisions, in the case of Lalita Kumari versus Government of UP in 2014, even the Supreme Court has made it very clear that it is mandatory to register FIR in all cognizable cases under section 154 of the code. Therefore, a police officer cannot refuse from registering an FIR of an information which discloses commission of a cognizable offence, and action must be taken against erring officers who do not register FIR in such cases. So, we can say that section 154 and Lalita Kumari case both have fortified the procedure for reporting of crime in cognizable cases. Now, after reporting of crime, if we try to trace the victim's role in investigation process, we will see that victim's participation in the investigation is completely dependent on the need of the investigating authorities. So, where the victim is required for any purpose by the investigating agency, he may be called upon by the police officer. But in section 157 subclause 2, the police officer is duty bound to report or inform the informant or the victim if he refuses to investigate the case for whatever reasons. Therefore, where the police officer takes a decision not to initiate investigation on an FIR registered, he must notify the victim of the same. Another important development in this regard is the case of Bhagwan Singh versus Commissioner of Police, 1997 decision of Supreme Court, where the court has stated that in cases where the police officer has filed a closure report or where the magistrate decides not to take cognizance of the offence on a police report, the court has recognized the right of victim or informant to receive notice about such decision. Therefore, in all these circumstances where the police decides to file a closure report or where the magistrate decides not to take cognizance on a report submitted under 173, it must be notified to the informant or the victim of the same. Now, after discussing the role of victim in investigation, let us see role of victims during trial. Now, victims are merely seen as an informant who set the wheel of justice in motion. Their role is limited to that of prosecution witness. It is the prerogative of a state to prosecute the accused. State appoints prosecutors to plead on behalf of the victim as well. In our country, the right of representation by lawyer is a fundamental right of every accused person, but the victim is not even allowed to prefer a lawyer of his choice to argue his case. Section 301, 2 and 302 give some scope for the intervention of the victim in the trial proceeding by allowing him to appear or appoint a pleader. But the pleader so appointed can only act under the directions of the public prosecutor. In 2008, a significant development is seen when a proviso to section 24 subclause 8 was added in the Code of Criminal Procedure to enlarge the scope of section 301 and 302 of the code. The proviso provided that the court may permit the victim to engage an advocate of his choice to assist the prosecution under section 24 subclause 8. Thereby, now the victim has also a chance or right to appoint a pleader who will be assisting the prosecution throughout the trial. This way, he can work as a watch advocate who throughout the trial will look into the development or of the case, or he may assist the prosecution in a way that the victim's right are also addressed during the trial. Now, let us see some other important phenomena or processes during trial where victim's right can be given recognition. First of all, it is plea bargaining. The provisions relating to plea bargaining in the code are also crucial as far as victim's role is concerned. Under section 265 capital C of the code, the victim is required to be served with a notice to participate in the meeting to work out a mutually satisfactory disposition of the case, including payment of compensation agreed. The victim is allowed to participate in such meeting with his pleader as well. Therefore, it can be seen that in plea bargaining proceedings, victims' rights are duly recognized by the code. Now, coming to the role of victim in bail proceedings, it can be seen that in granting or cancellation of bail, victims have substantial interest though not fully recognized by law. At the time of hearing on bail of the accused person, victim is not given an opportunity to present his case before the court, meaning thereby he is not allowed to state the reasons for cancelling the bail or for not granting the bail to the accused person. Though section 439 subclause 2 may allow a victim to move the court for cancellation of bail, but the action thereupon depends very much on the stand taken by the prosecution. Similarly, in cases of withdrawal from prosecution is another crucial stage in criminal trial. So, in such cases where the prosecution can seek withdrawal from prosecution, he need not to consult victim. Such withdrawal may either be generally or in respect of any one or more offences. Victim seems to have no right to challenge the prosecution decision at the trial stage itself. Therefore, as far as withdrawal from prosecution is concerned, it is the prerogative of the prosecution to take a call on whether he is going to proceed with the case against the accused or not, or whether he is going to charge the accused for one offence or another. That is the prerogative of prosecutor only, and victim has no say in that. Therefore, the matters relating to bail and withdrawal from prosecution are two different stages where victims' rights can be recognized, or victims may be given a more crucial role to play as far as victims' rights are concerned. Now, victims' right to appeal. In the year 2008 itself, by an amendment to the code, a proviso to section 372 was added, which recognized for the first time victims' right to appeal in cases where the accused has been acquitted, or where inadequate compensation is awarded, or where the accused is convicted for a lesser offence. The said proviso does not provide for victims' right of appeal for enhancement of sentence, which still remains the prerogative of the state under section 377 of the code. There are certain issues with this right of appeal of the victim. The first and foremost is whether victim's right to appeal need to satisfy the requirement of leave to appeal under section 378 of the code or not. Secondly, whether his right to appeal is independent of or subservient to the right of the state. And thirdly, where the victim is also the complainant, whether he needs to apply for special leave under section 378(4), or he can directly file an appeal under the proviso to section 372 of the code as a victim. So, these issues are yet to be decided in light of victims of crimes right to appeal. Now, role of victim in sentencing process. Indian criminal procedure law gives opportunity to an accused person to be heard on quantum of sentence under section 235(2) and 248(2). In countries like United States and England, victim statement is taken into consideration while sentencing the accused. In United States, it is known as victim impact statement, and in England, it is called victim personal statement. In India, victim is not given any such opportunity to be heard at this stage of sentencing. But in the year 2000, in this case of state of Andhra Pradesh versus Polamula Raju, the Supreme Court stated that it is an obligation of the sentencing court to consider all relevant facts and circumstances bearing on the question of sentence and impose a sentence commensurate with the gravity of the offence. The sentencing court must hear the loud cry for justice by the society, and more particularly in cases of heinous crimes of rape of innocent helpless children of the victim of crime, and respond by imposing a proper sentence. Therefore, indirectly in this case the Supreme Court has somehow opened the gate for hearing the victim of these heinous crimes at the time of sentencing as well.